Made it. I was worried.
Hello, everybody. Happy Tuesday. Welcome. I'm going to give a minute to let everyone log in and join us today. We have a good number logging on. Welcome, everybody. Happy week before a long weekend, hopefully, for many of you. Give another couple seconds to see if anyone else comes on. It's kind of slowed down. Hope everyone is doing well. All right, well, I am going to go ahead and get started since it is 12 o'clock and we have a short period of time as usual. I want to give Linda enough time to cover what she wants to cover. So welcome, everybody. Happy Tuesday. My name is Andrea Young. I'm the ECAC parent educator along with the communications lead. And today I am happy to have with us Linda Fields, who is the director of the UNC CARES program, and she is here with us today to share information about rethinking guardianship, exploring less restrictive options. So I'm going to hand it over to Linda because she has lots of valuable information to share with us.
Thank you so much, Andrea. It's really a pleasure to be with everybody today. I know my head is chopping off our little tagline, but CARES stands for the Center for Aging and Adult Research and Educational Services, and we facilitate systems change with and for adults of all ages. So we're very focused on people with disabilities, families, and older adults as well, and have been around since 1987. We engaged in a wonderful initiative funded by the North Carolina Council on Developmental Disabilities beginning in 2015 called Rethinking Guardianship. I have a long background in disabilities and aging work, and I stepped into UNC from lots of work in the state Medicaid program in Atlanta and a lot of work as a consultant with DHHS, both in Georgia and here in North Carolina. And so I was recruited to UNC and have been really pleased to work with a wonderful team there. I didn't know anything about guardianship before I got started with it in 2015. And once I peeled back the cover of what guardianship is, what it can mean, and the tendency within North Carolina and in other states across the country to overuse guardianship. It is certainly a very useful and important tool when necessary, but it has been overused. And it is nothing less than stripping someone of their constitutional rights to exercise their choice and self-determination as an adult. So we get involved in CARES at about 17 and a half, and we go all the way through the lifespan to the end of life. So with that, I'm going to share my PowerPoint, and I know we have very limited time, but Andrea will maybe tell you about some dates coming up or put those in the chat for a longer webinar, because the laws around guardianship in North Carolina changed thanks to Rethinking Guardianship beginning January of 2024. And I think it's really important for parents, teachers, and others to know what those laws are and how it changes your approach to guardianship. So with that, I am going to share my screen. Hold on. All right, and let me put it into slideshow mode, and hopefully you're seeing it now. Okay, so a new day for choice and self-determination in North Carolina, celebrating and looking ahead. It's just a real pleasure to be with you today. I just wanted to say briefly that I think many of you are parents or educators, and we can all trace our choices in life back to significant people. And I had some wonderful role models that really formed my career decisions. Mary Linden, who was the first person I met in Chicago when I was a swaddling little infant. I had cerebral palsy. I ended up being her healthcare and power of attorney later in her life. What is she holding? Well, she was the spokesperson for the Americans with Disabilities Act, and her testimony was used on the floor of the Senate when it was introduced in 1990. And so she had a tremendous influence on me. The people in the middle, this is my sister cousin. Our mothers were very close. We were really raised as sisters. Becky has cerebral palsy. She married her husband, Andy, in 2000. And they are, she was one of the first in 1975 to be able to go to school in integrated setting, the mainstreaming that you may remember. So I have one relative with the ADA, the other with mainstreaming and the IDEA, and then my parents who have since passed. And I was the power of attorney for them. There was some cognitive decline at the very end of their life. And thank goodness that they had put papers in place, because what do they all have in common? None of them had a guardianship because there were plans put in place. And so realizing that has made a big difference. I think one of the best ways to have the issue of guardianship driven home to us is to think about what rights are important to us. What is that pursuit of life, liberty, and happiness in the United States, the things that we get to enjoy as we are living in a free country, and what rights are important to you, and just think about them right now. You might want to jot them down. What are 3 major decisions you've made? Where you live, what you do, the relationships you have. So the question is, how would you feel if you didn't have the right to make these choices and someone made them for you and or took them away? Someone else decided where you lived. Someone else decided who you spend time with or who you don't spend time with. Someone else decides where you go to school, or if you go to school, all of those sorts of decisions being in someone's hands. That is what substitute decision making is. That's what guardianship is. And so it needs to be thought of very carefully before embarking on a petition for guardianship. People with greater self-determination, if they're making their own decisions with support, are more independent, more likely to work, more well-adjusted and healthier. And ironically, because very often guardianship is put in place to protect an individual, and indeed it can. So again, this is not a abolitionist view of guardianship. Sometimes it is necessary, and parents and individuals, with disabilities have to make those determinations individually. But it is interesting that the more agency a person has, the better they're able to actually recognize and resist abuse. So in a way, can be safer with that agency than having it taken away under a guardianship. And people with intellectual and developmental disabilities who do not have a guardian, and this is from the National Core Indicators, are more likely to live in their own homes or apartments instead of a group home, be involved in making choices about their lives, be included in their community, have their rights respected, have community jobs, be able to go on dates or get married. And I know everyone wants the very best for a child, an adult child, a child that is nearing the transition to adulthood. So these are really important things to consider. What is Rethinking Guardianship? It is an initiative that began in 2015, it continues to this very day, and we have a lot of work yet to do to promote less restrictive alternatives to guardianship whenever possible, and to create long-term changes in the state's guardianship system, which we did with the passage of a new law, which I'll just briefly touch on in a bit. I will not belabor all of the grants that we've written and received, but just suffice it to say that our history is 9 years of work leading to now. And all of these grants very often came from the North Carolina Council on Developmental Disabilities, but also from DHHS as they put their Olmsted plan into action. And we are now working on a less restrictive alternative educational grant to really create many more materials for families and individuals called After the Law. So what is this about? We're not talking about elders today, but many of you may have aging parents. And I hate to tell you, but we are all aging. If you are not dying, you are aging. And so it's really important that we all have a choice. And please, please do get your powers of attorney papers in place. You never know where you're going to need a substitute decision maker, and you want to be able to make that decision when you have the capacity to do that. There's been a lot of stuff in the press. I understand there's a new series out called The Bad Guardian. There was one called I Care a Lot. These are based on real cases where elders were really made or exploited through the guardianship system. Of course, most guardians are doing a fantastic job, but this has brought attention to this nationally and in North Carolina. Also, it's about adults with disabilities of all ages. Maybe some of you have heard of Jenny Hatch. She is this woman with Down syndrome. Behind her is Jonathan Martinez, who really began the National Supported Decision-Making Center. And she, in 2013, had the first successful case where she won her own guardianship. And you'll hear people whose rights are restored call themselves, I am my own guardian. That is such a precious right, to have your right to decision-making back. And her famous line is, I don't need a guardian, I just need a little help. And how many of us need a little help when we're making decisions of all kinds? I wouldn't buy a car without help from someone who knows or knowledgeable about cars. I just got back from a doctor's visit, physical. I can't make all my decisions on my own. I need the information and want the information from a doctor concerning my own health. These are examples of supported decision-making. The decision remains with me, but you ask your friends, family, trusted loved ones to give you information and help you with that decision. So here's the news. One of the leakiest little parts of the guardianship system, one is healthcare. And by the way, I was at the North Carolina Guardianship Association conference all last week. Healthcare is a perpetrator of sometimes undue and unnecessary guardianship. The other is schools. So there is this message that people just need to run down to the clerk's office and petition for guardianship at that period of time when a young person is transitioning to adulthood. This is from a report in the National Council on Disability from 2019, but it says for a variety of reasons, youth with IDD are disempowered by schools actively encouraging guardianship to the exclusion of less restrictive alternatives and not providing families and students with sufficient information about the availability of a full continuum of decision-making. Is that true in North Carolina? Yes. Unfortunately, yes. But awareness is growing. And I hope that this short Tool Time Tuesday session will help kind of wake up your mind to the fact that it doesn't have to be guardianship. It may be guardianship, but it doesn't have to be. Here's a great example from an LEA or a school district. The local education agency was ready to send out this brochure. Someone from DPI shared it with us, and it basically said, the guardianship process should begin if families and students feel uncomfortable with the transfer of decision-making abilities. The prospective guardian needs to petition for guardianship at the local probate court, which here in North Carolina is the clerk of court. I got on a call with Jonathan Martinez, and we suggested this change to the North Carolina LEAs. If a family and students feel uncomfortable with the transfer of decision-making, there are many strategies and opportunities to support the student's transition. Parents and students can learn about free and low-cost options by visiting, I'll show you this website in a second, Rethinking Guardianship and the National Resource Center for Supported Decision-Making at that website. And here's the sentinel line. As a last resort, parents may petition for limited or full guardianship at the local probate court or the clerk's court. So again, it's not that guardian may be what is the best option, but very often there are less restrictive alternatives that can be used. We had an opportunity, and I don't expect you to look at this very busy slide. This is from a poster session we did at the Exceptional Children's Conference a year ago. Actually, I think it was in the fall. Time has a way, doesn't it? And I think it's interesting. I'm sharing that same example. And again, it's about disrupting the school to guardianship pipeline for youth with IDD. I think what I want to call your attention to right here is the third column over the evidence. In 2021, they found that there are validated predictors for success after school, and self-determination has been previously identified. And there were identified 4 new predictors, including goal setting, parent expectations, travel skills, and get this, it's very applicable, youth autonomy and decision-making. The more youth are able to be part of and make their own decisions and practice making mistakes like the rest of us make with the support of trusted advisors and parents, the better off their success rate is post-secondary education. This was our statute writing team. We got really busy. We tried to pass new legislation to make less restrictive alternatives more important and to make people aware of their rights as they turn into adults and as they are within the process of adulting through life, even into elder years. So this group got together after 2 kind of unsuccessful tries for law passage, and we spent hours and hours, weeks upon weeks together during the pandemic, rewriting the statute, which in North Carolina is called General Statute 35A, special proceedings that basically govern adult guardianship, which is different from child guardianship. Just want to make sure that you're clear on that. We had success, and this is now a Senate law, 2013-124. It was Senate Bill 615. You can look it up in the North Carolina General Assembly bills. It's still existing there, and it's in the process of being codified into more permanent codes. But basically, this was signed into law September 28th, and it was enacted January 1st. From now on, every person for whom guardianship is sought has a clear understanding of his or her rights, both before and after guardianship. In the coming webinars, I will share more about what's contained in those rights. Both the petitioner is mandated to share those rights, personally serve them, as well as a guardian ad litem who comes out when a hearing is being established to go over rights. Guardianship is used only as a last resort if no less restrictive alternative is available. Petitioners have to now write on a new form why supported decision-making, why a power of attorney, why a fiduciary representative, why a joint checking account, why HIPAA consent for medical records would not suffice, and why a guardianship is important. So just be prepared, even if the school is saying, head on down to your local clerk's office to file for guardianship, you'll be stopped by the petition form saying, what less restrictive alternatives have you tried, and why are they not sufficient? Clerk is instructed to dismiss the case until that is actually filled out. So it's a very serious and an impactful new part of the law, intended to stop unnecessary and undue guardianship from happening. However, I get questions a lot from people who will say, you know, my son, daughter is just, you know, unable to speak for themselves. They're really, you know, none of those will work. Well, certainly that can be written and explained, and the guardianship would go forth, or perhaps a limited guardianship where something is carved out. And then finally, the courts have been given more effective tools for review and oversight to make sure guardians are fulfilling their responsibilities. Remember the slide about the elder woman. This is really focused on the guardians that have not been reporting to the state's clerks, and there are 100 clerks in the state of North Carolina. And there is just little known about what's really going on for those folks. Finally, I just want to take a moment and share this incredibly helpful website. And so all you need to do to get on it is to Google Rethinking Guardianship NC, or, you know, North Carolina Rethinking Guardianship. And you will be able to get here. I am going to stop my share here for a second, not my share, but to stop the slideshow. And I'm just going to pull up the link so I can just show you what's on there. As you can see, we change out these stories. This fantastic story of Tyler Freeman, who was pipelined to guardianship at age 17 and a half. 9 years later, at 27, he petitioned for his rights to be restored, and he talks about how incredibly meaningful that is. And then I direct your attention to a number of things, frequently asked questions here about what guardianship is, what it does, alternatives to guardianship, legislation, lots of videos and stories. And then I especially want to show you this because people will say, well, what is a less restrictive alternative? Well, we have separate sheets of these various less restrictive alternatives. Oh, and by the way, if you are interested in receiving a blog and new postings, once a month, it really isn't a lot. Put your name in here and your email, prove that you are not a robot, and we will be sending you information as it comes out. It's really helpful because we've been working closely with the School of Government to make sure that we're giving the latest and greatest on the new guardianship laws, and also just putting out more and more stories and making less restrictive alternatives easier for families to access. But let me show you this over here is what you want to open. And I'm going to open it for you. You see, it's available in both English and Spanish. You can download it and print it. We are in the process. We just got back from the Guardianship Association conference and got a lot of information from the DSS guardians as well as clerks of court. They want us to print these and send them to their offices. So you may be seeing this, but in your clerk's office, hopefully in your schools. Love to see a stack of these. Let me show you what's here. We are actually making another tool where you can put your information in, and up will pop less restrictive alternatives that make sense for your particular scenario. But here's a table of contents. Hope I'm not making anyone dizzy, just explaining things. General supports. Let me go to this here. Whatever you can see that you can highlight these and go straight to this. Say that you want to know how to create a supported decision-making agreement. In North Carolina, there is not a codified form, which actually our consultant, Jonathan Martinez, says is great. In fact, he thinks North Carolina has the best law right now in terms of insisting on less restrictive alternatives being considered, but not being driven to a different form that people have to fill out. Anyway, you can go through this, and as you can see, we developed it for the Council on Developmental Disabilities. So we took great pains to make it in plain language, not legalese. And it tells you about how to create a supported decision-making agreement. It would give you resources for finding templates and tools if you want to actually write that out. And every one of these forms has getting started. So step 1, decide what types of decisions you want help with. 2, choose your supporters and talk to them. 3, decide if you would like to make a formal plan for your support, for your decision making, and look examples of formal and informal agreements that you can find here. This goes on and on, so that here, hold on. If you need to close your eyes, I understand. I have motion sickness too. Here, for instance, let's say that you want to find out about, oh, I like this one, simple financial tools. One of my favorite stories is getting a call from a mom who said, my son is graduating from high school, and he has autism, and I want to find out how to get guardianship for him because he was on the football team and now he's ordered a bunch of footballs on Amazon, and I've had 8 footballs show up at my house. And I said, it may be, you know, this is not mine to call. I'm not an attorney and you have to make your decision on your own. But let me just say that my typically developing 17-and-a-half-year-old daughter orders all kinds of stuff. I get shoes, I get beauty products, though she doesn't need beauty products at the age of 17 and a half. So how about a simple financial tool? And if there's an agreement, it's no problem. If you have a relationship with your child, you can set these things up: a joint bank account, a limited debit card, a ceiling limit debit card. Work these things out with your bank. Maybe you can avoid a guardianship. So I'm going to stop there and say that I am really grateful to have been able to just share a little bit of all that acquired knowledge that we have gotten over the last 9 years, and also news about the new law, because I think any of you receiving messages that you need to go to the clerk's office and petition for guardianship, you will have a really different form to fill out than the parents who were filling out forms December 31st of 2023. So, and that's it.
Great. Thank you so much, Linda. I did just post the upcoming webinars. So Linda will be presenting this same topic, but obviously in much more detail over an hour and a half. If you're interested, on 2 different dates, one during the day and one in the evening. And I am also going to just post a link that will bring you to the flyer for those webinars so that you can register for them. And they are also on the ECAC website for further information. So before, I know we have a couple questions here, but I'm going to launch a quick poll. If everyone attending could just answer a few questions. The grant that we work on does require us to report back on what we're doing is useful, relevant, and of high quality. So we really appreciate your feedback. Let me just, where'd my polls go? Okay, let me just share that real quick and then we will take some questions. All right, if everyone could just kind of answer those quick questions for us, that would be appreciated. I do see one question here. Do courts provide language interpreters, especially Spanish, for all participating in the guardianship request process?
Well, each clerk's office is a little bit of a fiefdom unto themselves. And so I think the important thing would be to contact the clerk's office in the county in which you are seeking limited or full guardianship and ask for that. And you'll get information about that. I would imagine that question has come up before, and that particular clerk's office could give you information. I'm not aware of anything that blankets the entire court system for all 100 clerks of court.
One other question, someone missed where they can find more information on limited guardianship options.
Okay. Yeah, so on the website, if you look under frequently asked questions, there's some information there on limited guardianship. It is definitely so in some states, and kind of the trend internationally is to start with the least amount of support and build to the most amount of support. That makes sense. But in North Carolina, and this has been true in guardianship law in other states, what's imposed first is kind of the maximum full guardianship, and then the clerk gives back rights. So what needs to happen is for an exploration, and I think this can be asked by the parent, or the advocate can ask, can say, you know, I'm okay with John. I think that he's at a place where he can make some choices about, you know, where he lives, or what his healthcare needs are, or the people he hangs out with, but I'm really concerned about finances. You could say to the clerk, I'm seeking a limited guardianship and I'm concerned about this area. I will say that the guardians ad litem who will come and speak with you and your son, in this case, I'm using a son as an example, will go over the rights of an individual, and we'll also explore less restrictive alternatives. In North Carolina, all adult guardian ad litems are attorneys, and that's actually very handy because they will be able to say, gosh, could you set up a supported decision-making agreement? Is there a possibility for carving out one of these ceiling limit debit cards? And will that kind of, you know, with the cooperation of your son or daughter, could that avoid the guardianship? Do we not need to take those rights away? So limited guardianship, though, is something that clerks are getting more and more comfortable with. I just heard a big clerk panel discussion. They are so tuned into this less restrictive alternatives, and they see their job now, and 100 clerks will have 100 different ways of doing it. So I don't want to speak for all of them, but they're looking for applying the least amount of restriction on an individual so that a person can really realize their full inalienable right to become an adult in the United States and exercise their own choice. So anyway, so I would look on that frequently asked questions and you'll see some information about limited guardianship, but be your own advocate. So trust the family and the parents' view of this. It's hard to allow someone to make mistakes, but also consider how if you don't allow your loved one to make some mistakes, they won't learn about that. So they're lucky to have you for sure.
Great, thank you so much. Are there any other questions? We can probably take one more if anyone has a question. And again, definitely look into those June webinars where you'll get a lot more information on this important topic. And lastly, I just want to remind everyone we will be back next Tuesday in honor of National Foster Care Awareness Month. We're going to have Gail Osborne, who's the Executive Director of Foster Family Alliance of North Carolina. She'll be joining us to talk about their services, resources, and training opportunities. So definitely join us next Tuesday at 12 o'clock to hear from Gail. One other question we have, what constitutes incompetency in North Carolina?
Thank you for asking that question. So Patty, first of all, I am currently, just yesterday, working with a group of attorneys from the North Carolina Bar Association to eradicate the word incompetency. We're really looking for an alternative name that doesn't have that derogatory connotation. It is an improvement from lunacy and idiocy from before 1977, which is what people were called, which is just amazingly abhorrent. Can't imagine using it. Most states don't use incompetency. That's the first thing. So we're looking at, could we look at supported person or protected person or limited capacity, using different language. Second, incompetency used to be the only thing the clerk could do if you filed for guardianship. Adjudicate incompetent, apply guardianship, give back rights if possible. Now, the very definition of incompetency under the new law has changed so that if an adult is sufficiently able to manage their affairs with a supported decision-making tool of some type or some combination of those tools, they are not by law considered incompetent anymore. So you can see how huge that change is. The idea being all of us need support to make important decisions. If someone is able to use a surrogate or a supporter, an advisor, and that helps them manage their affairs, they are not considered under law to be incompetent anymore.
Great. Thank you again, Linda, for joining us today. And thank you everyone for joining us, and have a great rest of your Tuesday. Appreciate you being here.
Yeah, thanks everybody. Nice to meet you. I wish I could see your faces, but maybe next time. Take care.
Thank you.
Mhm.